Greetings and welcome back to 303 in Junior English and our continued study of essay writing. You are with me now on page 1382, 1383, and we're going to introduce you now to Ian Frazier, the author of the text. We're going to be studying Coyote and Acme. You'll see that he's on 1383. He was born in 1951. Let's read together. Humorist Ian Frazier was born in Cleveland, Ohio. He's a 1973 graduate of Harvard, where he wrote for the Harvard Lampoon humor magazine. After graduating, Frazier joined the staff of the New Yorker magazine. Now, you've heard this magazine named a number of times in our studies, and so it probably does make sense to Google the New Yorker, and the next time you're in a bookstore like Barnes & Noble, actually take a copy of the New Yorker down and just start thumbing through it for especially the cartoons that are in there. If you're a fan of cartoons, you're going to love the New Yorker. He worked at the New Yorker for 2 decades as staff writer. His work has appeared in many other publications, including The Atlantic, Washington Post Magazine, and Outside Magazine. You may be familiar with those magazines. A next heading, A Comic Sense. Known for both humorous essays and affectionate descriptions of rural and urban America, Frazier brings an irreverent sense of fun to much of his works. Coyote versus Acme is typical of his writing. A ludicrous premise packaged in serious style. Frazier has received many honors for his writing, including the Thurber Prize for American Humor and a 1990 Spur Award for Best Nonfiction from the Western Writers of America. He also has appeared on the National Public Radio program A Prairie Home Companion, acted in 2 movies, Smoke as well as Blue in the Face. His books include Dating Your Mom, 1986, Nobody Better, Better Than Nobody, 1987, Family, 1994, Coyote versus Acme, 1996, On the Res, 2000, The Fish's Eye, 2002, and Gone to New York, Adventures in the City, 2005. Many of my students love this quote at the bottom of the page in 1383. He says, I really like pieces where you start at the beginning and as you get further and further you realize this person has no idea what he's talking about, end quote. All kinds of irony in that line. Let's start now working at 2B. Let's start on page 1382 under literary analysis and the rhetoric or the rhetorical approach to our study of an essay by pointing out this is a parody. So write that down. There's your word, parody. What is a parody? At 2B, you ought to have that word written down. A parody is a comic piece of writing that mocks the characteristics of a literary form, a specific work, or the style of a certain writer. Through the use of exaggeration, a parody calls attention to ridiculous aspects of the original. This essay parodies legal language and argument. For example, my client, Mr. Willie E. Coyote, a resident of Arizona and contiguous states, does hereby bring suit for damages against the Acme Corporation. The purpose of this parody is to create satire. Let's write that word down. Satire. Writing that ridicules the faults of individuals, groups, institutions, or humanity in general. Although satire can be funny, we have 2 types of satire that we normally will identify. When you study with me in the senior year, we'll divide this up even more clearly into Horatian satire and Juvenalian satire, named after 2 Roman satirists of classical antiquity. Juvenalian satire is nasty satire, it's biting. So when somebody's making fun of you, other people might laugh, but you don't laugh in Juvenalian satire, it makes you mad. Horatian satire is kind of gentle, satire is kind of funny, and so you laugh along with everybody else in Horatian satire. Okay. Back to this reading here. Satire can be funny. Its purpose is not simply to make readers laugh, but also to correct the shortcomings that it addresses. As you read, think about the serious point Frazier makes in this parody of a legal document and whether the form and language of the satire bring out Frazier's main point effectively. Under reading strategy, this essay is organized using a cause and effect text structure. The lawyer for Mr. Coyote must prove that the poor design of Acme products cause results in injury to Mr. Coyote effect. To analyze cause and effect, look for words and phrases such as subsequently and resulted in that signal those relationships. Consider how these structural elements help to clarify the comic sequences of events the essay describes and the ideas it expresses. As you read, use a chart like the one shown to the outline cause and effect in this essay there on the right. By the way, pay attention to the 6 vocabulary words that are a part of this one. All right, let's go to 1384 and the background information to start with. This essay is the fictional opening statement of a lawsuit by Mr. Willie E. Coyote charging the Acme company with the sale of defective merchandise. If these names sound familiar, you may remember watching Willie E. Coyote chase the Roadrunner around the desert. The Warner Brothers cartoon Roadrunner and Coyote was popular in the 1950s. I'm stunned that I still have students who will report they still watch this, either online or on TV, cartoon channels, even though they're in high school, because it makes them laugh. Although, to be honest, it's somewhat dark comedy sometimes, right? More than half a century later, both the Coyote and the Elusive Bird are still going strong. As you read the essay, consider what Frazier is really satirizing, making fun of. The cartoon character who is his subject, or is he making fun of the legal profession? And let's go ahead and just say it right now, that this is an essay that you'll probably find satirical as a take on the legal brief, amusing, and you're going to find it enjoyable as well. The fictional defendant, Willie E. Coyote of cartoon fame, becomes an outraged victim whose terrible injuries are listed in detail. This brief's lambast of the Acme company for its supposed negligence presents a scathing but hilarious commentary on the litigious relationship between consumers and business. So, for those of you who may be at all familiar with the fact that basically people can sue other people for almost anything these days, you're going to have Ian Frazier kind of making fun of this in his classic essay. All right, let's just follow along. This is an essay I'm going to predict a number of you will probably enjoy very much because it's kind of darkly ironic, very sarcastic, and some of the people sitting in this room right now enjoy sarcasm quite a bit. So here we go.
Versus Acme by Ian Frazier. In the United States District Court, Southwestern District, Tempe, Arizona, case number B19294, Judge Joan Kujava presiding. Weil E. Coyote, plaintiff, versus Acme Company, defendant. Opening statement of Mr. Harold Schaff, attorney for Mr. Coyote. My client, Mr. Weil E. Coyote, a resident of Arizona and contiguous states, does hereby bring suit for damages against the Acme Company, manufacturer and retail distributor of assorted merchandise incorporated in Delaware and doing business in every state, district, and territory. Mr. Coyote seeks compensation for personal injuries, loss of business income, and mental suffering caused as a direct result of the actions and/or gross negligence of said company under Title 15 of the United States Code, Chapter 47, Section 2072, subsection A, relating to product liability. Mr. Coyote states that on 85 separate occasions he has purchased of the Acme Company, hereinafter defendant, through that company's mail order department, certain products which did cause him bodily injury due to defects in manufacture or improper cautionary labeling. Sales slips made out to Mr. Coyote as proof of purchase are at present in the possession of the court, marked Exhibit A. Such injuries sustained by Mr. Coyote have temporarily restricted his ability to make a living in his profession of predator. Mr. Coyote is self-employed and thus not eligible for workman's compensation. Mr. Coyote states that on December 13th he received of defendant, via parcel post, one Acme rocket sled. The intention of Mr. Coyote was to use the rocket sled to aid him in pursuit of his prey. Upon receipt of the rocket sled, Mr. Coyote removed it from its wooden shipping crate and, sighting his prey in the distance, activated the ignition. As Mr. Coyote gripped the handlebars, the rocket sled accelerated with such sudden and precipitate force as to stretch Mr. Coyote's forelimbs to a length of 50 feet. Subsequently, the rest of Mr. Coyote's body shot forward with a violent jolt, causing severe strain to his back and neck, and placing him unexpectedly astride the rocket sled. Disappearing over the horizon at such speed as to leave a diminishing jet trail along its path, the rocket sled soon brought Mr. Coyote abreast of his prey. At that moment, the animal he was pursuing veered sharply to the right. Mr. Coyote vigorously attempted to follow this maneuver, but was unable to, due to poorly designed steering on the rocket sled and a faulty or non-existent braking system. Shortly thereafter, the unchecked progress of the rocket sled brought it and Mr. Coyote into collision with the side of a mesa. Paragraph 1 of the report of attending physician, Exhibit B, prepared by Dr. Ernest Grosscup, MD, DO, details the multiple fractures, contusions, and tissue damage suffered by Mr. Coyote as a result of this collision. Repair of the injuries required a full bandage around the head, excluding the ears, a neck brace, and full or partial casts on all 4 legs. Hampered by these injuries, Mr. Coyote was nevertheless obliged to support himself. With this in mind, he purchased of defendant, as an aid to mobility, 1 pair of Acme rocket skates. When he attempted to use this product, however, he became involved in an accident remarkably similar to that which occurred with the rocket sled. Again, defendant sold over the counter, without caveat, a product which attached powerful jet engines, in this case 2, to inadequate vehicles, with little or no provision for passenger safety. Encumbered by his heavy casts, Mr. Coyote lost control of the rocket skates soon after strapping them on, and collided with a roadside billboard so violently as to leave a hole in the shape of his full silhouette. Mr. Coyote states that on occasions too numerous to list in this document, he has suffered mishaps with explosives purchased of defendant. The Acme Little Giant firecracker, the Acme self-guided aerial bomb, etc. For a full listing, see the Acme mail order explosives catalog and attached deposition entered in evidence as Exhibit C. Indeed, it is safe to say that not once has an explosive purchased of defendant by Mr. Coyote performed in an expected manner. To cite just one example, at the expense of much time and personal effort, Mr. Coyote constructed around the outer rim of a butte a wooden trough beginning at the top of the butte and spiraling downward around it to some feet above a black X painted on the desert floor. The trough was designed in such a way that a spherical explosive of the type sold by defendant would roll easily and swiftly down to the point of detonation, indicated by the X. Mr. Coyote placed a generous pile of birdseed directly on the X, and then, carrying the spherical Acme bomb, catalog number 78-832, climbed to the top of the butte. Mr. Coyote's prey, seeing the birdseed, approached, and Mr. Coyote proceeded to light the fuse. In an instant, the fuse burned down to the stem, causing the bomb to detonate. In addition to reducing all Mr. Coyote's careful preparations to naught, the premature detonation of defendant's product resulted in the following disfigurements to Mr. Coyote. 1. Severe singeing of the hair on the head, neck, and muzzle. 2. Sooty discoloration. 3. Fracture of the left ear at the stem, causing the ear to dangle in the aftershock with a cracking noise. 4. Radical widening of the eyes due to brow and lid charring. We now come to the Acme spring-powered shoes. The remains of a pair of these purchased by Mr. Coyote on June 23rd are Plaintiffs Exhibit D. Selected fragments have been shipped to the metallurgical laboratories of the University of California at Santa Barbara for analysis. But to date, no explanation has been found for this product's sudden and extreme malfunction. As advertised by defendant, this product is simplicity itself. 2 wood and metal sandals, each attached to milled steel springs of high tensile strength and compressed in a tightly coiled position by a cocking device with a lanyard release. Mr. Coyote believed that this product would enable him to pounce upon his prey in the initial moments of the chase, when swift reflexes are at a premium. To increase the shoe's thrusting still further, Mr. Coyote affixed them by their bottoms to the side of a large boulder. Adjacent to the boulder was a path which Mr. Coyote's prey was known to frequent. Mr. Coyote put his hind feet in the wood and metal sandals and crouched in readiness, his right forepaw holding firmly to the lanyard release. Within a short time, Mr. Coyote's prey did indeed appear on the path coming toward him. Unsuspecting, the prey stopped near Mr. Coyote, well within range of the springs at full extension. Mr. Coyote gauged the distance with care and proceeded to pull the lanyard release. At this point, defendant's product should have thrust Mr. Coyote forward and away from the boulder. Instead, for reasons yet unknown, the Acme spring-powered shoes thrust the boulder away from Mr. Coyote, As the intended prey looked on unharmed, Mr. Coyote hung suspended in air. Then the twin springs recoiled, bringing Mr. Coyote to a violent feet-first collision with the boulder, the full weight of his head and forequarters falling upon his lower extremities. The force of this impact then caused the springs to rebound, whereupon Mr. Coyote was thrust skyward. A second recoil and collision followed. The boulder, meanwhile, which was roughly ovoid in shape, had begun to bounce down a hillside, the coiling and recoiling of the springs adding to its velocity. At each bounce, Mr. Coyote came into contact with the boulder. Or the boulder came into contact with Mr. Coyote. Or both came into contact with the ground. As the grade was a long one, this process continued for some time. The sequence of collisions resulted in systemic physical damage to Mr. Coyote, videlicet flattening of the cranium, sideways displacement of the tongue, reduction of length of legs and upper body, and compression of vertebrae from base of tail to head. Repetition of blows along a vertical axis produced a series of regular horizontal folds in Mr. Coyote's body tissues, a rare and painful condition which caused Mr. Coyote to expand upward and contract downward alternately as he walked, and to emit an off-key, accordion-like wheezing with every step. The distracting and embarrassing nature of this symptom has been a major impediment to Mr. Coyote's pursuit of a normal social life. As the court is no doubt aware, defendant has a virtual monopoly of manufacture and sale of goods required by Mr. Coyote's work. It is our contention that defendant has used its market advantage to the detriment of the consumer of such specialized products as itching powder, giant kites, Burmese tiger traps, anvils, and 200-foot-long rubber bands. Much as he has come to mistrust defendant's products, Mr. Coyote has no other domestic source of supply to which to turn. One can only wonder what our trading partners in Western Europe and Japan would make of such a situation, where a giant company is allowed to victimize the consumer in the most reckless and wrongful manner over and over again. Mr. Coyote respectfully requests that the court regard these larger economic implications and assess punitive damages in the amount of $17 million. In addition, Mr. Coyote seeks actual damages, missed meals, medical expenses, days lost from professional occupation, of $1 million. General damages, mental suffering, injury to reputation, of $20 million, and attorney's fees of $750,000. Total damages, $38,750,000. By awarding Mr. Coyote the full amount, this court will censure defendant, its directors, officers, shareholders, successors, and assigns in the only language they understand, and reaffirm the right of the individual predator to equal protection under the law.
All right, so obviously one of the immediate questions that we'll ask is, what are your favorite lines from, from a piece like this, and why? But before we go there, let's jump back over to page 1386 for just a moment, and let's talk with this literature connection, parodies in American culture. Go ahead and read this with me again on page 1386 in that little box there on the left-hand side. There are many famous parodies in American literature, film, and music. You probably were already thinking about, for example, Mark Twain as you read this Ian Frazier essay. Mark Twain's novel, A Connecticut Yankee in King Arthur's Court, parodies the chivalric romance. Stephen Crane's story, The Bride Comes to Yellow Sky, parodies the Western. Popular culture is full of parodies as well. The films of Mel Brooks satirize absurd aspects of other movies. Spaceballs comes to mind, for example, or Blazing Saddles. Canadian Idiot, a 2006 spoof of the band Green Day song American Idiot, is only one of musician Weird Al Yankovic's many parodies. If you know about Weird Al Yankovic and his, making fun of all different kinds of videos and the like. Mockumentaries such as Best in Show and A Mighty Wind mimic the documentaries they parody by including fake confessionals and pretending to capture actual events. Of course, There's the classic parody as well of a number of years ago named Borat, which was a totally made-up film, but of course created a lot of controversy because of some of the things that filmmaker was making fun of. By the way, let's point out something important right away for your notes about this kind of parody. This kind of essay is really not that funny if what is missing. Write it down. What has to happen for this to be funny at all? Think about that. Think about it from this perspective. If you like Weird Al Yankovich videos, what has to happen for Weird Al Yankovich's videos to be funny? You have to have seen or be familiar with the original, right? Let's say, for example, that the picture on page 1387 of Willie Coyote with his, little bump on his head, or the picture on 1385 of Willie Coyote in his, arrow slingshot thing, and the runner of the road runner beside. If you had never seen this comic, this cartoon, then much of what's being referenced here wouldn't be funny to you. However, if you have seen it, and then you immediately can kind of see that big X painted on the desert floor, or you can see, those funky springs that he has on that he's about to release, and the boulder, of course, going bouncing. If you've seen that, right, and him walking away, and the accordion sound that's being referenced, if you've seen all that, then obviously this makes sense to you, right? However, let's go ahead now and move at level 1. All we have to say is this is like a court brief, a court document that says that the Coyote should be paid. Dude, did you see how much money they want him? They want the Acme company to pay in the end $38,750,000. Okay, this is what they want. Okay. Now, obviously, and some of you are already laughing, smiling here. Obviously, all of this is kind of a joke. But now let's ask at level 2A. What are we actually making